I'd like to spend the rest of our time today talking about exams in general and contracts exams in particular, because exams are important. They're not fun. They are very, very nerve-wracking to first-year students because they're not expecting, or they don't know what to expect, and not every professor will give you samples or a midterm. So I'd like to try and explain a few things, give you a few pointers. The caveat, of course, is I'm not the person grading your exam. And since I'm not the person grading your exam, you should ignore anything I say that contradicts your professor. Your professor is judge and jury come exam time. He or she is the one who will enter that grade, and therefore you should do what he or she asks you to do. If he wants you to write in purple pen, write in purple pen. Okay, so exams. Everyone's heard about law school exams. They're supposedly this horrible thing. Well, they're not really this horrible thing. I'm not going to tell you they're fun, but they are eminently manageable if you begin preparing from day one. And that's what law school exams are about. It is the conclusion of a long process, okay? So you're going to start preparing for exams on day one. All of your reading, all of your briefing, all of your class notes, all of your course summaries and outlines, all of those work together to help prepare you for that final day. That's why it's called finals. From the very beginning, you need to learn about law school exams. You need to learn about the exam format that your professor is going to use, and you need to learn about the substance that's going to be tested. Now, I'm going to talk to you a little bit about what law school exams are. And I'm also going to remind you that your law professor is going to tell you about your exam. Now, some of us do it very expressly. Some of us will stand up and say, you will have a 3-hour closed book exam. There will be 2 hours of essay and 1 hour of multiple choice. Others will not be so forthright or express unless you ask them. They forget. Others will say it will be some combination of multiple choice and essay and don't give you specifics. It doesn't matter. You want to garner as much information as you can. Some will say it's all essay. Some will say it's open book. Whatever it is you want to know as early as possible in the process. Before you ask your professor, though, always check the syllabus. Many, many schools require professors to put that information in the syllabus, and it is much better to have read it and looked informed rather than to ask the question. Okay, so we'll talk more about format of the exam in a bit, but the other thing is substance. What's on the exam? Now, by substance, there are two components. There's the what topics did we cover in class that will be tested. For that, listen to the express statements of your professor, and listen to the implied ones, the ones where they tell you, oh, that's my favorite topic. Think about it from their perspective for a moment. They have to read 30 or 50 or 100 essays on a particular topic. Don't you think they'd rather read it on a topic they like than the one that they hate? So, if your professor sits there and tells you, oh, this is the best topic, it is probably more likely to be on an exam than the one that says, this is a topic. Just a thought. Again, listen. If the professor keeps coming back to it and stressing it, if the professor spends a third of the class on it, the overall class, not one class session, it is much more likely to be a large portion of the exam than if you spent 10 minutes on one day on it. So you will have a good idea of what substantive issues are likely to show up on an exam if you pay attention. It's not a secret. You just have to pay attention. Now, additionally, law school questions tend to be a little bit different than other exams you've likely taken. On a law school exam, at least on a law school essay, you are likely to get a fact scenario, a set of facts followed by a question. Now, there are two categories of questions. There is what we know as the general call, discuss everyone's rights and liabilities. Or there's the specific call. Is Joe liable to sue for X, Y, and Z? Read the question carefully. You'll need to be able to figure out, do I have to answer an identified issue, or do I get to go fishing for whatever issues I can find? We sometimes refer to the general call question, the discuss all the rights and liabilities you see question, as the kitchen sink, an issue spotter. If you get one of those, you need to go through and identify all of the issues and address them. But you may not have as much time to address them in as much depth as if it's a specific call which says, discuss whether Joe is liable to sue for this. That is a much more focused question. Now, while you might not see this clearly right now, the multiple choice questions are miniatures. Almost any multiple choice question, and certainly the multiple choice questions you'll see on something like the bar exam, are mini fact patterns that could be an essay. Only they ask you a very specific call for which you must give a discrete answer, choosing one of the choices. I'm not going to spend a great deal of time on multiple choice here, though if your professor is testing on multiple choice, you should make a point of learning more about how to take those kind of tests. Okay, so the general law school essay exam. You read the facts to spot the issues. What legal issues are raised by these facts? Now, luckily, law school exams are compartmentalized. In contracts class, you're going to answer contracts questions. You're not going to answer property and torts questions. Okay? In torts class, you're going to answer torts questions. You're not going to deal with property and contracts. So remember what class you're in when you walk into an exam. Remember that in contracts, it could be a contract about the sale of land. Or like the hairy hand case, it could be a contract about what looks like it could also be negligence. So you want to remember to say, what class am I in, and address the issues that are relevant to that class. It is incredibly important to be fact sensitive. We professors spend a great deal of time, energy, and effort crafting creative fact patterns for you to work with. Sometimes we try to make them funny, sometimes we don't. But we know what we've taught, we know the cases we've read, we know the nuances we want to raise, and we go through and we create fact patterns that expressly raise issues. Probably issues that don't have a concrete answer, that could be argued either way. Once you have identified the issues, remembering that professors do not necessarily test everything they taught, they want to know if you can distinguish what's there from what's not. Once you've identified those issues, you need to be able to spit out the black letter law. As I said when we discussed course summaries, it is important to have that internalized, automatic. The rules should come out in a split second. This is not where you want to spend your time on an exam. Once you've stated the rule, you need to go about breaking it down into the component elements or factors so that you can apply it. You need to actually use the facts that we so carefully created for you under the law. So you need to tell us that, oh, that fact shows that Joe did agree because Joe said, I really want to enter into this contract. And Joe sat there for 2 hours signing the agreements and negotiating the agreements. And all of the facts have to actually be used. Not repeated. Not just said, oh, this is a fact scenario where Joe did this and Sam did that. We don't need you to repeat the fact scenario. We wrote it. We need you to use the fact scenario. And then once you've done that, once you've deconstructed the rule and used the facts to analyze and explain, then you might want to predict an outcome. Now, law students like to say liable or not liable. But most of the time, you are making a huge assumption if you come to a single conclusion. On most law school exams, there is an argument both ways on most of the issues. Not on all of them. Some of them might have an answer. But on many of the issues, there is an ability to argue either way. And if you read a set of facts on an exam and immediately see there can only be one answer, stop. Take a deep breath and say to yourself, what did I just assume? What did I read into this question that I'm only seeing one side of it? If I had to represent the other side, what would I be arguing? Make yourself see the other side of the exam. Okay, so that's a little bit about what the exam is going to be in terms of format, essay questions versus multiple choice, about the types of questions that are asked, and about how to figure out what will be on the exam. Now, one of the big questions all law students have is, what about study groups? Should I be in a study group? Do I want to be in a study group? Are study groups good? The classic law school answer is, it depends. It depends on what kind of learner you are, what kind of studier you are. Study groups can be incredibly helpful if you choose them wisely. What do I mean by that? It's not a one-size-fits-all. What works for me might not work for you. Study groups can be a great asset if you use them based on how you learn best. They can range from 2 of you taking a walk to discuss the issues to a group of 4 of you that meet regularly to review cases or synthesize materials or practice hypos. There is no discrete answer. I don't generally recommend bigger than 4 to 5 because that gets too unwieldy. I don't recommend working with people beyond 1 or 2 times if you find that you're not being productive. I know it's very hard to extricate yourself sometimes, but it's important that you choose something that works for you. And in that set of circumstances, if you're finding that Joe talks too much about other things, you say to Joe, I'm really sorry, this group just doesn't work for me. I'm just finding I don't learn that way. Don't worry if it's that Joe talked too much. Go do something else. So try to choose people whom you work well with, which means don't go out and form your study groups the first week of law school. Get to know some people. Go to lunch, go to dinner, talk about classes during breaks, see whom you seem to connect with. See who seems to be able to work with you. Then try it out. A lot of people want to form their study group the first week of law school and they don't know anything about each other. And they may work well or they may not. So take some time and explore before you commit to that. Again, study groups can meet regularly or they can meet just around exams. It may be for many people, and it certainly was for me in law school, that I like to do all of my preparation and synthesis by myself. And then towards the end of the semester, I like to get together in very small groups of 2 or 3 and talk about issues or questions. What worked best for me is to take turns explaining topics. We would each take a Roman numeral on the syllabus and take turns being the teacher. And everyone else got to ask questions. And we found that if we could each explain it to the other, we must know it. And if we seemed to be messing up, someone was giving us feedback. So for me, that was an incredibly effective tool. Again, it's different for each person. One of the advantages of working in groups is that you get to brainstorm questions. What kind of variations might the professor give? Now, when we were talking about Hadley versus Baxendale, I modernized it. I could create an entire modern day example that would be a different take on Hadley versus Baxendale. You all could create that yourselves too and talk about why changing certain facts would change the results. Because this helps you identify the nuances that a professor might change and recognize them when you see them in the fact pattern. You also can review each other's answers. Now, here's something I'm going to recommend. I recommend it to every student every year, and the ones who do it really learn from it and appreciate it. Take the time to write out your answer. Or type it if you're going to type. But actually take the time to do sample questions under exam-like conditions. There is nothing that replicates doing a sample question under a timed, closed environment. No books, at a desk, with other people in the room if you do it in a study group, timed. the more you practice doing it under exam-like conditions, the less stressful exam-like conditions will become, and the more able you will be to just attack the problem head-on and not worry about the fact that, oh my God, it's an exam. Okay. The law school semester is 14 weeks. In many respects, it flies by faster than you can imagine. But in some respects, it is a very long path. And I will remind you all that it is important to keep balance. You cannot do it all in the last 2 weeks. I have yet to meet the student who in the last 2 weeks can put it all together and excel. You cannot stay up all night for 4 nights in a row before your exam and expect to be thinking clearly enough to read those facts and see all the nuances. Okay, I've had so many students come in not having slept the night before, take the exam, and when they come in and reread the question 2 days after they get their grade, oh my God, I didn't see that. Well, yeah, you could barely read straight. You hadn't slept in 2 days. That's not going to help you excel. So remember to maintain your schedule and your balance. Eat, sleep, exercise. These all help you moderate your stress, keep your brain functioning well, and doing better. Okay, some general exam tips in no particular order. Some schools require you to type your exam. If so, practice exams typing. Some schools will give you a choice. If so, practice the way you intend to do it. If you are going to type your exam, then practice typing answers. If you're going to write your exam, then write out answers, because you lose track of how much time things take or how things work. It's just important to practice in the mode you're going to use, okay? Exam instructions. Read them and follow them. Some of us are pretty picky about our instructions. For example, before computers became so prevalent and all of my students hand wrote, I required them to write only on one side of the blue book every other line. Well, I learned to be very specific because I used to limit them to one blue book, and I had one student once write 2 lines of text for every line on the book. And that was not what was intended. So if we have instructions, we expect you to follow them. Remember, we're grading it. You really don't want to irritate us by not following our instructions. We try not to penalize you beyond whatever penalty is mentioned on the exam. And by the way, my penalty for violating the rules is not to read that question. But we try not to penalize you beyond that, but you do lose the benefit of the doubt. And you don't want to ever lose that of your grader. Time management. We've been talking about time management. Everyone talks to you about time management. It's key. With respect to exams, there's the semester time management of preparation begins on day 1, and you've got to leave time for creating the course summary, and you want to be done in time to use it to study. You've heard about that already. There's also the time management of allocating your time among the various questions, and then allocating your time within each question. For example, if your professor tells you there'll be 3 essays of equal length, then you know on a 3-hour exam you probably want to spend an hour apiece. You don't want to spend 2 hours on the first essay if it's only worth 1/3 of the points. Okay? Many law students in their first set of exams lose track of time. You don't want that to be you. Okay? Sometimes professors will give you time allocations. Sometimes they'll give you point allocations. Either way, pay attention. If it's only worth 1/3 of the points, you don't want to spend more than 1/3 of your time on it. It is unlikely you will ever get a perfect law school answer except on possibly multiple choice. On an essay, you're never likely to get a perfect answer because there's always more than one. So you rather get 90% of the points and move on than get 96% of one and none of the last because you ran out of time. I cannot stress to you enough the importance of allocating your time among the questions and sticking to it. Beyond that, once you decide you're going to spend an hour on this question worth 1/3 of the exam, how do you allocate your time within the question? I promise you that at your first exam, There's going to be someone who opens the essay, reads through it once, opens the blue book, or starts typing. And other people are going to get nervous and say, oh my God, she's already writing. I better be writing. No. A substantial, and I mean substantial portion of your law school exam time in any question is reading, thinking, and organizing. Students who start writing at the beginning often get halfway through and say, oh, I missed that. Cross out, start over. If you have limited space, you've just wasted a ton of space, let alone time. So generally speaking, read, think, and organize. As you read, make note, what's the question? Was it a general call, I'm looking for anything? Was it a specific call, I'm looking for specific stuff? Make notes. Unless you are told you may not, unless you are told you can't write on the exam, make notes on it. Actually write on the piece of paper with the question. Circle things, but make a jotting of why you're circling it. For example, if it were an offer and acceptance question, go through and circle and say, offer question mark, add question mark, acceptance question mark, termination question mark. But don't just circle or underline, because then you haven't identified why and you have to go back and spend more time thinking about it. If you take the extra second to make a jotting, oh, offer, just an O in a circle, you'll remember when you look at it again. And when you get to the point of writing later on, you can go back to your facts and say, oh, there are my offer points. So read the question carefully. I always recommend you read the question twice. Now, I'm going to stress this because I think it's really important. The first time you read the question, read it slower. Consciously read it a little slower. Many, many people read over things or misread things. And if you do that the first reading, your brain will do it the second reading. You are unlikely to be able to catch it until some amount of time has passed and you can look at it fresh. So if you read it wrong the first time, even though the words are different, you'll see it wrong the second time. So I know it's hard, you feel time pressure, but take an extra minute or two to read it slowly and carefully and make sure you're reading what's actually there. Not what you want it to be there, not what you hoped would be there, but what's there. As you go through it, make those notes and ask yourself, talk to yourself, have a conversation, do it in your head. Your classmates won't like it if you start mumbling out loud. But have a conversation, say to yourself, why did she include that fact in the exam? What's the relevance of that? Now, there may be one or two red herrings, facts that are thrown in that really have no relevance. But on a law school exam, most of the facts are there for a reason. So if you find you're only focusing on 3 of the 17 facts in your problem, go back, you're missing something. In a contracts question in particular, focus on the timing, when things occurred. Contracts questions follow a process. You have to create the contract, then you can figure out what the contract said and whether people did it, and then you have breach. Timing in your problem has to be provided to give you an idea whether this is a formation issue and a question of whether we properly formed it, or whether this is an established contract and the question is whether you breached it. So particularly in contracts questions, focus on timing. And I'll repeat this several times today. Answer the question you are asked. You might write a perfect answer to another question, and you will get few, if any, points because it was not the question asked. You're totally right, but you're not relevant. So answer the question you are asked. I told you need to spend your time reading, thinking, and organizing. How do you organize your answers? Do you do it by timeline? Do you do it by person? It depends. If you're dealing with for example, an offer and acceptance question, well, chances are you're doing a timeline because offers have to come before acceptance. You can't have an acceptance before you have an offer. So those tend to be chronological questions. On the other hand, if you have one of these kitchen sink criminal law questions where all of these bad things happen and you have 3 people and you have to say which crimes did each of them commit, that question you might more properly want to deal with by person, or you might even want to do it by crime. Again, as you prepare your course outline and summary and as you synthesize, you'll get ideas as to the ways you want to organize and structure different types of questions. A real important note, a couple of real important notes on writing out your answer. Number 1, a lot of stuff is going on in your head, and you've made a lot of notes. You have to make sure that you put complete answers in the blue book or on the typed exam. I have found many, many people have made notes on their outline, and then when they get to the actual exam, they just write the conclusion. And when we go back and look at it together, they say, but I knew that. And when we pull out their scrap paper, sure enough, it was there on the scrap paper. But I don't grade the scrap paper. So the whole answer has to be included in the exam book. If it's in your head, it might be right, but there are no points for it. So make sure you are actually putting down onto the paper the complete answer, not just the conclusion or a part of it. Okay? One of the ways you make sure that you are not only identifying the issue and stating the applicable rule, but that you are using the facts is my favorite Wizard of Oz joke. The most important word on a law school exam is because. Every time you state a rule, you should say it's satisfied because, it's not satisfied because. And after that because, there should be a fact. This fact shows you X, Y, or Z. This fact means that. Use the facts. Apply the facts. Don't just state these facts are there. Use them to show why things are met or not. Because. Beware of pronouns. Be very careful of pronouns. I have had students talk about 2 male characters in a question and then say, he. Who's he? Which one? I don't know. I cannot make assumptions when I grade your exam. I can only give points for what is on the paper. And if it is unclear, I can't give you points. So be very careful when you use pronouns. Oh, and use headers and paragraphs. And if you don't believe me, go back and look at the Hadley versus Baxendale case and tell me it wouldn't have been a heck of a lot easier to read if they'd added a few more paragraphs. Remember, we are sitting there reading, many of them typed these days, but still many handwritten, pages and pages and pages. And the more reader-friendly you can make it, the better off you are. If I have to scan your handwriting and try to figure out the words, I lose the flow of what you were saying. So if you have messy handwriting and are allowed to type, you might want to type. If you're going to use abbreviations, make sure your professor allows it, and make sure you define them the first time if they're not commonly accepted abbreviations in your classroom. As for structure, how do I structure the answer? You might hear about things like IRAC and CRAC or CREAC or all sorts of acronyms. Those are designed to be paragraph structure guidance. Okay? IRAC, for example, stands for Issue, Rule, Analysis, or Application, Conclusion. Issue, Rule, Analysis/Application, Conclusion. That is not for the problem I list all my issues, all my rules, all my analysis, all my conclusions. No. That is for every single issue. I should state a rule, analysis, application, conclusion. And they should be discrete paragraphs. Also, you need to prioritize. If you get one of those general kitchen sink essays where you're going to get to raise every issue you can find, prioritize. If you spent 7 class periods talking about A and 1 talking about B, you should spend more time on the exam discussing A than you should B. Because I'll bet that in most of the circumstances, there are more points available for A than for B. So use common sense and good judgment when you take your exam. It seems that law students want to check that at the door when they enter an exam. Don't. Bring yours with you. Use it. IRAC or CREAC are very good for certain kinds of questions, but they're not good, for example, on a policy question. And if your professor says he hates IRAC, don't mention it. Don't say you're using it. It's still important to remember to assert your issues and rules and give an analysis and conclusion. But you don't have to call it IRAC if your professor hates IRAC. Okay? One of the most common problems I see on first-year exams is the brain dump. Students get into the exam and they want to show me, I learned everything you told me. Let me show you. Let me throw up on paper. I'll give you credit for it. I am sure you have memorized everything I've said. But that's not going to get you a good grade on the exam. Because I'm not looking for a regurgitation of what I said. I'm looking to see if you can apply it to the next set of circumstances. If you can recognize which of those is relevant in the fact scenario and then apply it. If you can distinguish from what's relevant from what's not and then give me a good statement of the rule and give me a good application of these facts, why these facts satisfy it or don't, why they're similar to the case that satisfied it, why they're different, why it might be like that case, but this one thing makes it hard. That's what I'm looking for. Unless your professor told you they want a brain dump, don't do it. Now here's where you have to listen to your professor. Some professors do want you to go through and say, this is satisfied because, this is irrelevant because. That's not what I do. I tell people I only want them to address what's relevant. But some professors do give points for an explanation of why that's not relevant. You need to find out what your professor wants, and you need to give it to that professor. Another very common error. You change the facts for the question you wanted to answer. Don't do it. We wrote a question to raise certain issues, and we want you to address those issues. If you change a fact, you're likely to address a different issue, and that's not what we asked for. Okay? So don't change the facts. Also, don't argue the facts. If we give you something, if we tell you X, accept it. If we tell you Joe and Sam entered into a valid contract, this is not a question about whether there's a contract. Don't spend your time and energy talking about, oh, well, clearly they had a contract. Yeah, you were told they entered into a valid contract. Don't waste your time and energy talking about whether there's a contract or not. You don't have the facts to do it. It's clearly not what's asked for, so skip it. Also, be careful with the use of the word if. If tends to indicate you're changing something. Now, there is a proper use of if in exams, and there is an improper use of if in exams. I find that students who use if at the beginning of an answer are using it incorrectly. They're changing facts. Students who get halfway through their analysis and realize, ooh, you didn't give me that fact. If that fact turns out to be this result. But if that fact turns out to be that, a different result. That's an appropriate use of the word if in a law school exam. Somewhere through your analysis where we left out, usually intentionally, a fact, because how that fact goes gives different responses, and we want to know whether you can catch that, whether you see how relevant that missing fact is and what obtaining that fact will do to your analysis. So those are some of my general overriding issues on how to take an exam. What I'd like to do now is I'd like to take it into the contracts context and see if I can help you with what I'm going to call a roadmap. Now, when I talked about course summaries, I said it's important to synthesize. The thing that worked best for me in law school, so what I will share with you, is creating a roadmap of how I was going to approach different kinds of problems if they came up. Okay? I told you that contracts is fairly linear. You have to go through step 1, step 2, step 3, step 4. There's a series of steps, and depending on what happens, you know what to talk about. As you do your course summary, if you create a 1 or 2 page roadmap, you will have the guidance to know when you read the facts, oh, she said there's a valid contract. This is not a formation question. I should skip that part of my outline and see what it is a question on. Oh, an aside for all exams again. Law professors have limited time and space to test you. It is unlikely that they will test the same issue twice on the same exam. There will be something different about it. It is the very rare professor that is trying to trick you by testing the exact same thing twice. Most of the time, if you're seeing the exact same thing, you're missing something. So before you write the exact same answer, oh, this is another negligence issue, this is another formation question, it's the exact same, look again. Double check yourself, because that's often an indication you're on the wrong track. Okay, so I'm going to give you my roadmap for contracts in the sense of trying to give you the overriding framework. Now, clearly, as you haven't studied all of contracts yet, I'm only going to give you the bare bones framework, but hopefully it will be something that you'll find useful as you continue through your career. In any contracts exam, there are always 2 preliminary questions. Most students like to forget about these, but they are important. The first, as you read your question, is to always do the initial cut. Is this about a sale of goods where I'm governed by the UCC? Or is this a services or land contract, which is common law? Or is this a mixed question where I might have to do both? I might have to figure out the court could disagree, and I have to give my analysis both under the UCC and under the common law. That's a preliminary question you should always be asking yourself. Sale of goods UCC, common law, or a question that could go either way, so I need to do both. Another thing, particularly if your professor is focused on the international aspect, is this a domestic or international dispute? Because different rules might apply, and you have to be able to peg it. All right. Once you have cleared those threshold questions, we start at the very beginning, the inception questions. Do we have a contract? Do we have an enforceable promise? The formation questions, okay? That is the mutual assent we talked about, plus the concept of consideration, which you will learn about. And the question is, do we have a contract? Well, the decision tree there is if you have a contract, we're going to continue down our contracts analysis. But if you don't have a contract, does the law provide any other basis for enforcing the promise? Many of you will study promissory estoppel and promissory restitution, which are equitable alternatives if there's something wrong with the formation process and we didn't get a contract. So in the formation area, you're saying, oh, do I have a contract? Did I have my offer, acceptance, and consideration, my mutual assent and consideration, or did something go wrong? And if something went wrong, then I'm going to look to my alternatives. What might go wrong? Well, they are the defenses to formation. Those are things like something was wrong in the contract process, or something was wrong with the people involved, so that we don't find a contract. For example, there was fraud or misrepresentation. You were contracting to do something illegal or against public policy. You were contracting to do something under duress. I was holding a gun to your head. You were contracting to do something, but you were drunk or only 12. You were contracting to do something, but the society finds it unconscionable. Or you contracted to do something verbally, and the law required it to be in writing. That would be known as the Statute of Frauds. So, if you have a contract, if you have mutual assent plus consideration, and there's none of these problems in the formation process, and none of these problems that say, no contract, then we continue on our way. Now remember, if the facts said, we have a valid contract, you skip that whole step. But note what I'm doing here is I'm creating a decision tree. I can look and say, am I at this stage? If so, here are the sub-issues I want to be looking at. And under each of those, in your course summary, you'll have memorized the rule of law and the elements and the factors you're going to have to use to show whether it's satisfied or not. If, in fact, you find a valid formation, or if, in fact, you were told there was valid formation, the next question goes to, what are the performance questions? Well, clearly, to figure out if someone performed, you have to know what they promised. You have to know what the terms of the contract are. And there you'll study something called the parole evidence rule. And there you'll study interpretation. How do we view the meaning of these words? You'll look at things like express conditions and constructive conditions. When must I do things, and when does the law imply conditions? Once you've figured out what the parties have to do, then you get to the question of, did they do it? Did they perform, or are they in breach? Now, if they perform, everyone's happy and goes home, and that's probably not a great contracts exam problem, so that's probably not what you're going to see. The question is, if they didn't perform, are they in breach, or is there an excuse? There are a series of excuses for performance, like it was impossible, or it frustrated my purpose, that allow me to get out of liable damages. I don't have to pay you damages. I'm not liable if, in fact, I didn't do what I promised to do, even though I didn't do what I promised to do. So we've seen now that we've found a contract, we figured out what the contract says, and now we're discussing whether the parties did what they said they would do, and if they didn't, whether there's some reason to excuse it. If the parties didn't perform appropriately and there's no excuse, that's when you turn to remedies. That's when you turn to the issues we looked at today. And as I said at the beginning, I do my liquidated damages clause first because the issue there is, if there's a liquidated damages clause in the contract, you have to determine its validity before you turn to other mechanisms for determining damages. And again, if you begin to see, and this is very early on because you haven't studied all of these issues in depth, but that is a macro picture of the world of contracts. The one other issue that comes up, if you study it, and not all classes will, are third-party rights. That is, if there is a third party out there who's entitled to the benefits, or a third party out there who's going to do your work for you. Those are easier to spot in fact patterns because there has to be some third party who wasn't a party to the contract. So when you have third parties running around your contract, that should ring bells. And as you study, and as you do your course outline, and as you create examples and non-examples, you begin to develop in your head series of facts that you say, oh, that's going to raise this, or that's going to be similar to that. When I see that, it's going to say, oh, that reminds me of this. And that's how you begin to analogize and distinguish the various issues. I'll conclude by reminding you that this is a semester-long process. You will be ready for exams when you can quickly and easily articulate the rule of law and end the test to determine whether it's satisfied. So not only spit out the rule of law, but also spit out the elements or the factors. When you can read a set of facts and in your brain you start seeing, oh, that raises formation. Oh, that's a remedies question. When the facts start seeming familiar or close enough that you realize that's that area versus that area. And when you have practiced actually applying the facts to these elements test or these factors test to give posited conclusions, often not definite conclusions, because often one of you could argue it one way and another side could argue it another way. And on an exam, you would very much like to try and argue both sides unless you are expressly told to write a judicial opinion supporting one conclusion. I will leave you with those thoughts and wish you well in your study of the law.